Belgica vs. Ochoa. GR number 208566, November 19, 2013. Facts: this case is consolidated with GR number 208493 and GR number 209251. The so-called pork barrel system has been around in the Philippines since about 1922. Pork barrel is commonly known as the lump sum, discretionary funds of the members of the Congress. It underwent several legal designations from Congressional Pork Barrel to the latest Priority Development Assistance Fund or PDAF. The allocation for the pork barrel is integrated in the Annual General Appropriations Act or GAA. The PDAF articles in the GAA do provide for realignment of funds whereby certain cabinet members may request for the realignment of funds into their department, provided that the request for realignment is approved or concurred by the legislator concerned. Presidential pork barrel. The president does have his own source of fund, albeit not included in the GAA. The so-called presidential pork barrel comes from two sources, a. The Malampaya funds, from the Malampaya gas project, this has been around since 1976, and b. The Presidential Social Fund, which is derived from the earnings of PAGCOR. This has been around since about 1983. Pork barrel scam controversy. Ever since, the pork barrel system has been besieged by allegations of corruption. In July 2013, 6 whistleblowers, headed by Ben Herloy, exposed that for the last decade, the corruption in the pork barrel system had been facilitated by Janet Lim Napoles. Napoles had been helping lawmakers in funneling their pork barrel funds into about 20 bogus non-government organizations, which would make it appear that government funds are being used in legit existing projects, but are in fact going to ghost projects. An audit was then conducted by the Commission on Audit and the results thereof concurred with the exposés of Loy et al. Motivated by the foregoing, Greco-Belgica and several others filed various petitions before the Supreme Court questioning the constitutionality of the pork barrel system. Issues. Issue number 1. Whether or not the Congressional pork barrel system is constitutional. Held, no. The Congressional pork barrel system is unconstitutional. It is unconstitutional because it violates the following principles. A. Separation of powers. Under the pork barrel system, what's happening was that, after the GAA itself, a law was enacted. The legislators themselves dictate as to which projects their PDAF funds should be allocated to, a clear act of implementing the law they enacted, a violation of the principle of separation of powers. Note in the older case of Philconsa vs. Enriquez, it was ruled that pork barrel, then called a CDF or the Countrywide Development Fund, was constitutional insofar as the legislators only recommend where their pork barrel funds go. This is also highlighted by the fact that in realigning the PDAF, the executive will still have to get the concurrence of the legislator concerned. B. Non-delegability of legislative power. In this case, the PDAF articles, which allow the individual legislator to identify the projects to which his PDAF money should go to, is a violation of the rule on non-delegability of legislative power. The power to appropriate funds is solely lodged in Congress, in the two houses comprising it, collectively, and not lodged in the individual members. Further, nowhere in the exceptions does it state that the Congress can delegate the power to the individual member of Congress. C. Principle of checks and balances. Under such system, how can the President veto the appropriation made by the legislator, if the appropriation is made after the approval of the GAA? Again, Congress cannot choose a mode of budgeting which effectively renders the constitutionally given power of the President useless. D. Local autonomy. With the PDAF, a congressman can either bypass or duplicate a project by the LDC and later on claim it as his own. This is an instance where the national government, note, a congressman is a national officer, meddles with the affairs of the local government, and this is contrary to the state policy embodied in the Constitution on local autonomy. It's good if that's all that is happening under the pork barrel system, but worse, the PDAF becomes more of a personal fund on the part of legislators. Issue number 2. Whether or not presidential pork barrel system is constitutional. Held. Yes, the presidential pork barrel is valid. The main issue raised by Belgica et al. Against the presidential pork barrel is that it is unconstitutional because it violates Section 29 Paragraph 1, Article 6 of the Constitution. Belgica et al. Emphasized that the presidential pork comes from the earnings of the Malampaya and PAGCOR, and not from any appropriation from a particular legislation. The Supreme Court disagrees, as it ruled that PD 910, which created the Malampaya Fund, as well as PD 1869, as amended by PD 1993, which amended PAGCOR's charter, provided for the appropriation. These are sufficient laws, which met the requirement of Section 29, Article 6 of the Constitution. The appropriation contemplated therein does not have to be a particular appropriation, as it can be a general appropriation, as in the case of PD 910 and PD 1869.